Dee, I just wanted to. Are we ready to start? Are you ready? Okay. Can I just say something right from the outset? These hearing aid dispenser advertising guidelines are based on existing law, and they were drafted a long time ago, the original ones. And I think back when it was a bureau before the board's time. And then the board revisited this about, I think, 5 years ago. When I came on board, there was a regulations packet on my desk, one of many that we were trying to address. I think that we are really close now, and if we are spending 45 minutes, an hour, it's good time invested in these regulations. I think they're necessary. I'm concerned about us not spending the time and actually having to revisit this in 2018 and still talking about this in 2019. So I just want to commend the board. I think we're making good progress here. We're really close. The letter F, we may be trying to solve a problem that really doesn't exist. We're trying to clarify what's already an existing law and a way to help advertisers comply with that law. Right, Sabina? Okay, so if we can go back to F, I think we were trying to come up with some language on the additional charges.
Additional charges, and then leave it at that.
Thank you, Paul. No, thanks for saying that.
The simple statement should be, if you even want to say that here, but additional charges may apply.
So it's an advertisement.
Could we read again? I mean, I have scribbled here what I think it is, but it's changed so many times. Does anybody? Okay, wait. I'll just take that on. Can I?
Yes.
Advertisements shall fully disclose any and all additional charges, I can't read my own writing, including for hearing aid features, accessories, and services.
I think we're going to take out the including and just put additional charges, period.
Okay, so we're just going to stop at charges.
Yes.
Okay.
Does everyone agree with that?
So, could you read one more?
Okay, one more time.
Advertisements shall fully disclose any and all additional charges, period.
Legal counsel? Okay, good.
I had a couple other edits that I wanted to bring to the board's attention. So if you're on the first page on subsection C, starts with advertising by a person licensed to dispense hearing. I think it should be aids
Yes.
after.
You think?
Kind of exceeding our
Dispense
authority
hearing, you'll
there.
be out of work.
Yeah.
Then down to subsection D as in dog, subsection 3 under there. A job title or dispenser certification, is that possessive, dispenser certification?
Yes, apostrophe S.
Okay. And then on subsection 4 under that, so the next one, the first sentence states an offer to perform a hearing test that does not clearly state that the test is being performed in order? Okay.
Yeah.
Instead of in offer. And then following sentence, an offer for authorized services as part of a research study does not violate this section if no selling of hearing aids occur or a hearing aid occurs. So I'm not sure what the grammar, if you want plural.
I went with,
A hearing aid occurred, okay. And then I had maybe you guys can help clarify number 6 for me. Preset appointment information when the consumer has not requested such an appointment. Now, can you explain how maybe, because if I read an advertisement, I know I haven't asked for an appointment.
This would be like if somebody received a postcard or a letter and it said,
Okay.
"We've reserved time for you at 1:30 on Tuesday, November 14th."
Okay,
Yeah.
clearly,
And telephone calls.
Right,
Okay.
this is
Uh-huh.
tactic.
Yeah.
Yep.
okay.
Yeah.
Clearly, if I'm just reading the penny saver.
Yeah. You're
Okay.
not going to see that.
Got it.
Yeah.
Okay, and then subsection E as in electric. I don't know what the phonetic is. Sorry. Edward. There you go. The first sentence, the use of rebate coupons and rebate checks without informing the consumer of all the variable and material. Should we go back to facts? That's similar to 651 instead of factors. Relating to the actual price of the device, it should be device instead of devise.
This is British English, yes.
I would think.
Yeah.
Okay.
Yes, no, it should be device with a
Those
C.
are the
yeah.
only edits I had.
Okay.
I have a question.
Could you say
It
that
says
last one again?
at A, the beginning, a person licensed to dispense hearing aids
In E?
may advertise, and then we talk about it.
Wait, I'm sorry.
Paul?
I'm
I'm
sorry.
asking, is this section covers also dispensing audiologists? And if yes, where is it mentioned or how it is applied?
So this is the first line
Yeah.
of item A, a person licensed to dispense hearing aids. Yeah, that would be
So
either an
that's
audiologist or a
also
dispenser.
dispensing. Okay.
I would assume.
I mean,
Sorry, what did you want to change?
no, not to change.
Oh,
I
Yeah,
want to ask
yeah.
where does it says that it's applied to dispensing audiologists besides hearing aid dispensers?
Because an audiologist,
Have
a
to.
dispensing audiologist is a person who is licensed to dispense hearing aids.
Okay.
I am licensed to dispense hearing aids.
Yeah. So it will be enforced on the dispensing audiology as well.
Oh, I would certainly assume so,
Okay,
Paul,
I
right?
want to ask Paul.
It says a person licensed to dispense hearing aids.
Yeah.
They're
so-
licensed to dispense hearing aids.
Yeah.
Yeah. Okay.
That's how it has been, and I'll check. We'll look into that.
Yeah.
I think now we're at the point of entertaining a motion.
So, you gotta make a motion. to
Because
accept.
I believe that this section 1399, 197, I think it's part of a hearing aid dispenser law.
Yeah, I cannot hear.
Is section 1399.127 advertising, is it section of a part
Okay,
of a hearing
Amnon,
aid?
we have auditory problems here. You need to pull the microphone down
Okay.
closer to your mouth, and
Yeah.
I'm having a hard time hearing you
Wow.
over you two guys, but I know you two guys need to converse with each
I
other.
want to know if section 1399.127 is a section that it's also only in the hearing aid dispenser area in the law.
Currently, that's where it resides.
So that's my question, if legally, if it's also applied to we know it's applied, but I'm talking legally if it's applied.
So for those of you that maybe are not following what Amnon is asking, we have our regulations are separated because of the way the board and the bureau were set up. And we have a section for speech language pathology and audiology and a section for hearing aids. So I guess the question is if the regulation states a person licensed to dispense hearing aids and that resides in the section for hearing aid dispensers,
Spencer, right.
wouldn't it also apply to an audiologist?
It should.
It should,
It should.
but I'm saying if an attorney defending and dispensing audiology will come with this technicality and said, hey,
Yeah.
that's why
I know that we.
yeah, I wanna
This is under miscellaneous, does that help?
It's in the miscellaneous, but it's under,
hearing aids.
well, we're lucky enough to have an expert here. Kurt? You're not paying attention?
No.
Yeah.
An audiologist has to apply as a hearing aid dispenser.
Yeah, I know.
Right, so they're
So
licensed.
they are,
Right,
and
yeah.
sometimes some of them don't even combine their licenses, and they're a separate audiologist
Right.
and a separate hearing aid dispenser.
Let me make sure that Kurt understands our question, and I'm sorry,
Liz.
Kurt, that we're kind of, putting you on the spot here, but
No worries.
we have,
what he's here.
our regulations were obviously, right, the origins are from,
Bifurcated, if you will.
right, and when we merged the law, for some reason, there was a difficulty in merging the regulations into one, so they remain separate. But that regulation states a person licensed to dispense hearing aids. An audiologist who dispenses hearing aids is a person who has to get a specific license to dispense.
Correct.
And the question is, does that give us the authority to enforce these guidelines upon a hearing aid dispensing audiologist? Thank you.
In my preliminary opinion would be, Mr. Sanchez, that the way this is constructed, the plain meaning would be any person within a license category or classification that is authorized to dispense hearing aids would be subject to this regulation.
Okay. Okay.
And it
No
kind of
matter
further
where it
clarifies
lives.
that under section C, subsection number 2.
yeah, putting the dispensing audiology
Okay.
in the advertisement.
Thank
no
you,
matter-
Marty.
Or training.
Thanks, Kurt.
That was from Karen.
Okay, so now I think we need to entertain a
So
motion, right?
we have edits, proposed edits. The ones I pointed out, should you decide to accept those and ask the staff to go ahead and update that language, and then you have your proposed subsection, new subsection F. So that's what we have right now, unless we have other edits to the language or suggestions.
You also made some edits to the
right.
second page,
One,
between A and B, changing the word or to and.
So is the motion to,
And-
yeah.
and is the board still interested in taking out that such as the manufacturer's suggested retail price in that subsection as well?
I don't see the harm in leaving it in. It says such as, it doesn't say limited to. And if there is an MSRP, it's just a way of, it's a way of clarifying what we're talking about. Do you see any harm?
I think we decided that it was not necessary to have.
Yeah,
the
if
Okay.
you put if you put something, it might cause a problem. If you don't put it, it's
Okay.
better.
EFG.
So it would read then, list the dollar amount of the non-discounted fee for the hearing aid or provide consumers with a method to ascertain the actual price,
That's it. Yeah.
period.
Yeah.
And we are or are not including B.
Yes, that's correct.
Yeah. We don't need to.
Are we including B or not including
I
B?
thought we took it out.
Okay,
Oh,
so it's out?
Well, then
Yeah,
there
we
is no
took that
and.
out.
Okay. Okay, period.
So the first motion is.
I wonder if there would be,
The second one.
I wonder if there would be value. I know we've been working on this for a long time. I feel like we're coming to closure. Would there be value, Paul, in deferring this one more time to where we actually just see the language? No strikeouts, no, just so that we could read it from start to finish with no scribbles, no strikeouts.
That would be nice.
I think so too, personally.
Well, in my opinion, we only have two edits that we're looking at. One is that it has to do with any additional charges, and the other is actually eliminating that sentence.
Eliminate sentence.
We are going to, the next step would be to notice this for a 45-day period. So we would have time to make
Okay,
any
good,
changes. We're going to
good.
revisit it again anyways.
Right, okay.
I'm just
good.
concerned about waiting another
Right.
3 months to
Yeah.
decide on the same thing.
I forgot about the notice. So yeah, that does make sense.
So she's getting a motion for us.
Can I say something?
Sure.
Okay, you guys were talking about on the second page, line item 1, subcategory B, to scratch out B, list the dollar amount of the discount, the percentage of the discount of the specific hearing aid. I think that's the only place where you have the specific hearing aid listed in all of that. So if you eliminate that, then you're eliminating the requirement of having the specific hearing aid on the advertisement.
Could we add the word specific? That's a good point. Could we add the word specific back into 1A, the dollar amount of the non-discounted fee for the specific?
Yes.
Okay, so what we could do is before we entertain a motion, we'll read those two sections again with the substantive changes that we've made, and then we'll entertain whether there's a motion.
and Kurt has a couple others too.
It's a good point, though.
Yeah.
Thank you, Madam Chair, members, executive officers, and staff. My name is Kurt Hepler. I'm a supervising attorney with the Department of Consumer Affairs. Just a couple things. I think your counsel, the esteemed Ms. Knight, are on the same wavelength. Just drawing your attention to the last section, subdivision I. It is unusual in I sub 2 to say a hearing aid dispenser will be held liable for sales. Generally, in our world, we say things like subject to discipline or subject to enforcement. So the board may want to consider that.
EFG.
It's the second page.
Two,
Page I sub 2,
I sub 2, a hearing aid dispenser will be held liable for sales. Yeah, that's a
right.
that's a
So,
good suggestion.
and then, as
Right.
I think I pointed out, I think you have a subdivision H missing, because
Yes, there is.
Oh,
Okay.
okay.
So, but again, those are not at least the nomenclature, the wording, or the is not so. With that, and I think if legal affairs, legal counsel will be more than happy to work with you moving towards a polished and final product. So with that, I'll be quiet.
So then I'm wondering if the motion could be with final edits.
There's a lot of edits.
Yeah,
Okay, so just to clarify, the edits that we're talking about there are a few grammatical edits, but we're talking about 2 sections and now a 3rd section that we have already worked through the language. So my suggestion would be to clarify what those changes are, and then to move forward with the 45-day period. So can we just
Let's
go through those one more time so that everyone knows what we're saying? We just went over F, and that was, do you have that? Somebody, do you want to read it?
I think Allison had it.
Okay.
Advertisement shall fully disclose, is it any and all? or-
Advertisements shall fully disclose any and all additional charges.
Okay, that's F. And then the next one was G1. And I think you helped us with that one, Sabina.
List either the dollar amount of the non-discounted fee for the hearing aid or provide consumers with a method to ascertain the actual price
Of a specific hearing aid.
of the specific hearing aid.
Okay.
And everything else is struck out.
And then, as Mr. Hepler pointed out, which would now be H.
Right.
Subsection 2, a hearing aid dispenser's license will be subject
Could be
to,
subject to discipline. Is that what we
First-
want to say?
for sales resulted from a national advertisement that violates this section.
Read that again, please. Will be subject.
Is it more appropriate or more accurate to say hearing aid dispenser's license will be subject to discipline, or hearing aid dispenser will be subject to discipline?
Well, we discipline the person. We don't discipline the license. The license is just
But
a license.
I thought we disciplined the
Let's get Mr. Heffler back over here.
license.
So a couple of questions. One is, do we want to specify the license, Kurt? And do we also want to say anything about dispensing audiologists here? Should we just leave it simple and say hearing aid
Or-
dispenser?
This is sort of, to be candid with you, sort of a distinction without a difference. Technically, when we discipline an individual, we discipline the license. We constrict or restrict the license. But since the individual holds the license, I think that's perhaps a distinction at this case without a difference. My only concern with 2 would be that a hearing aid dispenser just say is subject to discipline, because the disciplinary decision rests with the executive officer as to whether to initiate it or not. So, and I reserve the balance of my time and can answer any questions, and I apologize. I'm a little bit unprepared, and my eyesight's going bad because I was trying to read it on my phone and the language on my phone, and so thank you. So I'll be happy to answer any other questions.
So just to clarify what it would read, a hearing aid dispenser is subject to discipline for sales resulted from a national advertisement that violates this section.
Shouldn't it be sales resulting?
I'm just going to make that comment.
Thank you.
For sales results.
I have a question.
Sure.
Since we don't consider cite and fine disciplinary action, can we say discipline or a citation or enforcement action?
Right.
Okay.
So is subject to discipline or enforcement action?
Right. For
I have a question about this section also. Since we're talking about dispensing audiologists and hearing aid dispensers, would specifying hearing aid dispenser in that section be confusing as far as whether it would apply to a dispensing audiologist? Should it be rephrased as a person
Person
licensed to
licensed to
dispense hearing aids? And would that be more clear?
so we just take the
Or hearing aid dispensing licensee, but I like what Rod said better.
A person licensed to dispense hearing aids.
just take that.
A person
From A and put it
licensed
into there, I think.
to dispense hearing aids.
I like that, yeah.
Okay. So now, I'll read it again. A person licensed to dispense hearing aids is subject to discipline or enforcement action for sales resulting from a national advertisement that violates this section. Period.
I have,
One more.
maybe it's just a question why we're still here down on subsection F. 1, exempt from said advertising is paragraph C. But paragraph C, if you turn back to page 1, maybe you could explain to me how that works. So, a national advertisement is exempt from all of these conditions?
Yeah, I want to explain to you this. I have written this pursuant to a Miracle Ear dealer that was here when you were not attending here, and he said the Miracle Ear putting
I'm not,
advertising.
just if I could just interrupt, I don't think we want to be specific with specific advertising. We could just say, when we refer.
It was in an open meeting
Okay,
here.
okay.
The Miracle Ear name was in an open meeting here, so it's not. And they said, look, they're putting national advertising for us. They cannot list all the addresses and names and telephone number and license number in all the thing. That was the exemption that we gave.
So we're saying that the national advertisements are exempt from all the things we talked about in section C, but the hearing aid dispenser is subject to discipline for anything that violates this section.
Yeah, the violate because there's about not putting the exact price and other misleading advertising. If they will put there 65% of MSRP, Miracle Ear, call 800, and you call New York and they give you a dealer here, this is this ad is violation. But if they put just the name, 800 number, and some feature of a hearing aid which is correct, and you call and you get a dealer here, this is okay. We just exempt them from putting the addresses and the license number of 100 dealers that they have here in California.
So subsection C addresses only the retail
Yes.
business address and the license number of the person licensed to dispense the hearing aids.
Yeah.
I see. Okay. So you just talk about the name and the number. Okay. Did you have anything, Vanessa?
No, I was just going to mention that for HHP, that had been the overriding concern, was that we didn't want to make the ads too lengthy so that you might unintentionally encompass, hundreds of licensees. So that's it. Thank you.
Okay. So not all the things we're talking about, just C.
And
Sorry about that.
Yes.
And we
See.
very much appreciate the board's attention to our concern on that.
Yeah, just see.
I was just noticing there's an advertisement weekly in the Chronicle where another agency, they list every location, actually. There's probably 10 addresses at the bottom of that ad.
Many of them do.
Yeah.
Yeah.
Okay, so we have the language.
Okay.
And then, so to recap, we have those few, if I can remember where we are. We have those, some grammatical corrections pointed out here, and then we have the subsection F that was reworked, subsection G1 that was reworked, and then subsection H2.
Sorry, considering this discussion we just had, do we have to add that exemption about the addresses to this?
Oh, it's already there.
It's already there?
I was just trying to figure out what it really meant.
Where is that?
Exempt from said advertising.
See, okay.
This section.
Okay, thank you.
So I think now we are ready to move forward
With the language,
with the board's,
changes.
right. Is the board ready to move forward with this to the next step?
I move to adopt this
You want to have them read the motion?
advertising proposal with the changes
We need to read that.
Is that we're directing the staff to do?
Yeah, I could,
Yes.
would you like me to read the motion?
Yeah.
Okay, so the motion would be,
You have to add this in there.
okay. Do you want to read it? Because I'm not sure. I think they just need to know what the motion is.
Right. So we're at the point where we can go out for a 45-day period, right? This is brand-new language, right?
Yes.
Okay. So that we move to approve the proposed text for a 45-day public comment period and to delegate to the executive officer the authority to adopt the proposed regulatory changes as modified and to follow the established procedures and processes established by the department and to make any technical non-substantive changes that may be required in completing the rulemaking file.
I move.
Second?
Comment? Comment, discussion.
We have comments from members of the board.
Yes, yes.
Hallelujah.
There's a comment.
And then, of course, we'll have the opportunity to view the public comments that come back in and consider them before we put through. Yeah, okay.
Absolutely.
Yeah.
You will see this again.
We'll see this ad nauseum.
Is
Yeah.
there any discussion from a member of the audience? Okay. That being so, then let's call the vote.
Yes.
Yes.
Aye.
Yes.
Aye.
Yes.
Yes. Okay. The motion carries. Okay. Lunches have arrived for some of us, and we'll take a break. How long do you want to give people to eat?
You want to do part working, part not?
Yeah.
Working lunch?
What are we talking about? Do we usually do 30 minutes? We're going to say 45.
No,
No.
let's say,
Let's see.
we say 15, we really
Yeah.
got 30.
Okay.
And that's how, you
Okay,
know,
we'll go
that's how that works.
Too fast? Too fast, okay. We do deal with. So if I choke, yeah, raise your hand. Our next item is 14B. This is regarding the speech-language pathology assistants. And Patty's going to give that report.
Actually, I think this is,
You've got it.
actually, I think
Oh,
this is
is that
just,
hers?
you know, Karen's going to tell us what step in the process we are. And I think we left out something in the last, you can explain what we're doing here. We're reviewing comments, right?
Yeah, we were reviewing comments to the last 15-day comment period that came out and just ended about a month ago. And so we did receive comments that were duplicative of comments that we received prior to this. So these are our suggested responses to those comments.
It
Okay,
sounds like all the
Karen,
comments were
can you
rejected.
just summarize all of the comments and what the board's position is on them? Board staff position?
Recommending.
Right.
Okay, one of them is regarding employing SLPAs. There's a requirement for 20% immediate supervision for the first 90 days when you have a new supervisor or a new SLPA coming into being together, just to make sure everybody's on the same page and knows what each expect of each other. This comment was received previous to it, so we are rejecting the comment because it does not affect the changes that we made to this last 15-day comment period. And then they were talking about enforcement.
We're on number 2
question.
now? Number 2?
Number 2,
Okay.
yeah. Some enforcement issues on what's appropriate, not appropriate, what can a slipper do and not do. That was a comment that was brought up at a previous comment period that we addressed. So we are also rejecting this one because it was not specific to this last 15-day comment period. And then number 3 is reporting violations. Anybody can submit an anonymous complaint. The only time we have problems with it is if we need more information to go forward with the complaint. There's not somebody to get a hold of to get additional information. But however, anybody can submit in a complaint, whether they want to give their name or not. So because that's a comment that was made prior to it that we addressed, we're rejecting this one again because it's not specific to this last modified text.
Okay, so we've made some recommendations to the comments that have been submitted, and now we're asking for the board to approve our
Approve these,
recommendations.
Right, to go into the rulemaking file.
And once this is approved or disapproved and you want to make changes to the comment, the recommended responses, once this is done, I will finish up the final statement of reasons, and it will go back to DCA for a final review, and then it is due back to Office of Administrative Law by October 20th.
I have 2 pages. They appear to be identical, but
Yeah,
is there a
I have
difference?
also.
Is there a difference?
2 pages on the same.
Yes, it looks like they're
Okay,
identical.
yeah.
Okay.
But we're not missing anything.
No, we're not missing anything. It's just the 3 comments.
So that's what we need, motion or discussion on the motion.
So is there a specific motion that we want at this point?
So are we going to accept the staff's recommendations for the responses?
Okay.
We can have a discussion first.
So we're entertaining a motion and then discussion.
Wait, you turn on your microphone.
Entertaining the motion, accepting what staff recommended to us.
Staff recommended responses
Yes,
to the comments.
the
received
responses to
during-
the comments.
Right, comments received during the 15-day notice period, comment period.
I will second your motion. It was on, and it went, it's shorting, I'm saying, I'm serious, this one
I
needs
see
work.
that it's happening.
I will
this way.
I will second that. Yeah.
Did we have a motion?
We need a motion.
I thought you just made the motion with help,
Did you make-
excuse me.
Okay.
I'll be happy to make the motion. I so move what Sabina just said. So
Okay.
we'll go with that.
So we have a motion and a second.
Okay, any discussion from members of the board?
I would like to just comment that if we received these 3 comments, and I understand the reason that they were rejected, and that makes sense to me, but it does beg the question that there apparently, in some format, maybe needs to be more explanation or effort made to explain. Because the fact that these 3 questions came up, these look like valid questions and important questions, and I realize that they're not pertinent to this particular motion, but nonetheless, some people are having these questions. So maybe there needs to be, some FAQ that accompanies this discussion that helps to address these 3 questions and perhaps others that came in. Because otherwise, why are people asking these questions?
I think what we would like to do is respond to these specific people, these specific commenters, and let them know why they're being rejected. For instance, if someone says that there's a concern about anonymous complaints, that's a perception that we talked about yesterday. People, consumers, anyone can file a complaint to the board anonymously. And that wouldn't be that wouldn't have anything to do with this. That was already addressed. I think that's the issue, that they're not relevant to this
But
15-day comment period.
Does the text here of this statement suggest that it was addressed previously, the issue? Because it says, but rather the prior proposed text and was addressed at that time. Does that mean it was?
Yes.
Yes, these same questions were submitted at the so we had the 45-day comment period, then we had a 15-day comment period, and those questions were submitted and addressed at that 15-day comment period.
Oh.
And then Office of Administrative Law, the attorney that's assigned to this regulation, noted some other corrections that needed to be done in the text. And so that's why it went out for this second
Oh, I see.
15-day
Okay,
comment period.
now I get it. Okay,
Okay.
yeah.
Any discussion from someone in the audience? Okay, if not, we'll call roll.
Yes.
Yes.
Aye.
Yes.
Aye.
Yes.
Yes. Okay, motion passes.
The next one is 14C, and it's general rules regarding fingerprint requirements. As you recall from our last meeting, we talked about the issue of fingerprints and the board having authority to request fingerprints from those people that have not been fingerprinted. I'll let Karen kind of give us a summary of where we are with this too.
Okay, at the May board meeting, we came in with a language that was presented back in like 2010 and approved by the board. There had been some changes to the statutes that Noreen had noted, so she changed some things. And so this is the new text. It's identical in the hearing aid side and the speech and audiology side.
Applicant for renewal, are you a licensee?
So I just have very slight, minor change. It's in two different places here. Looking at number 1, item D on the first page. It says a licensee directed by the board to comply with the requirement for fingerprint submission in, I think the word in should be changed to and that's the only change. And A shall retain for blah, blah, blah.
Isn't that referring you back to subsection A? Above?
Is that what it is about? Requirement for
So it should probably say subsection A, right?
Above or in sub.
All right, then if it's not and, yeah, then I think,
Subsection
yeah, that might be a better idea. It's confusing.
Right, so I think that's redirecting you to subsection A above.
Okay, so then,
And there's a period missing at the end of that sentence, or at the end of that section,
Yeah.
section D as well.
so the same, it should be item 2, section D. It's the very same thing, so it should say in subsection A.
What was the last one, Patty? I'm sorry, I missed that.
On the second page, item 2, subsection D, it's the very same sentence. So licensee directed by the board to comply with the
Oh, I got it.
requirement for fingerprint submission in subsection A shall.
Right.
Yeah, it looks like it's missing a period also.
And subsection F as well.
Karen, Noreen Marks provided this to us, and this is consistent with other language that has already gone through the process and been approved with other
Yes.
boards, correct?
Yes.
Okay. But with the periods.
Correct.
How do a licensee know if his fingerprint are already in file or not?
They will be notified.
Oh, they will be notified.
So we're asking the board to approve the recommended changes so that we could get the ball rolling on these regulations. And we're looking for that magic motion that we make, magic language.
Is that what you want
So
to hear
moved.
now? Wait. I didn't get to say it. We move, or I move, if you are so moving, that we approve the proposed text with edits with the proposed edits for a 45-day comment period and delegate to the executive officer the authority to adopt the proposed regulatory changes and to follow established procedures and processes, and to also delegate to the executive officer the authority to make any technical and non-substantive changes that may be required in completing the rulemaking file.
So moved.
Is there any further discussion possible? I was just saying, under section 1B, it also ends with A. Should that be changed to subsection A?
Yeah, I think so.
So identifying that the references to subsections
Right.
will include the word subsection.
Right.
In these edits. Thank you. And that all periods
All periods are there.
have been added.
So we have a motion to that effect?
I just did.
I second it. Any discussion?
So at the bottom of that page, any other restriction on a license or registration held, is that the end of the sentence?
That's where that period is missing.
Oh, that's another missing period. Okay. And it's missing again then on F.
Yes, D,
Yeah.
D and F.
Yeah, yeah.
It's technical,
Yeah.
non-substantive changes.
Any discussion from members of the audience? If not, we'll call the roll.
Yes.
Yes.
Aye.
Yes.
Aye.
Yes.
Yes. Motion passes.
Zipping right along.
At this point, I would like to invite any audience members who have joined us this afternoon to identify themselves if they would so choose.
And I'm Sean Talbot, the Executive Director of CASHA as well. So thank you for having us here today.
Thank you for coming.
Okay, we're moving on to 14D. And this is a proposed regulatory language for the hearing aid dispensers that specifically affects the hearing aid dispenser's examination. As I've mentioned in the past, these regulations, some of the regulations we have are very, not very, but they're outdated and they don't work today. And we are trying to streamline some of those processes and make sure that, especially when it comes to the practical exam, when a few years ago we had a real backlog of people that wanted to take the exam, but some of the limitations that we had had to do with the language that specified exactly when an application can be filed, no earlier than, no later than, and that limited the board to only 50 per examination. Well, we made a lot of changes to our exam that actually allow us more flexibility, so we want the regulatory language to reflect that. And Marty has kind of led the effort with staff to come up with some proposed language. You have anything else to add?
Huh?
You want to talk about it?
No.
Do you want to go over the language that we discussed with our legal counsel the other day?
So one of the main, go ahead. So one of the main changes that would like to make is section E, where we take out the not sooner than filing for the practical examination, not sooner than 51 days nor later than 30 days prior to the date set for the examination. it's not clear, really limits what we're trying to accomplish. So we've changed it to the board will publish a minimum 10-day practical examination application filing period. So it's at the discretion of the board of when we want to open that filing period. And a maximum number of candidates will be determined by the board for each examination, instead of capping ourselves at 50.
I still not clear for me. When you say 10-day, there will be a window of 10 days to apply?
Yes.
My question is, why can't people apply throughout the year and you stage them?
Because we don't want to keep an application and their $500 check.
Oh, I see. We can work with the money or something.
And there's also a prerequisite to taking the practical exam. That's passing the written exam. So we need some time to work through that.
Yeah, so how soon in advance the public knows of this window?
Well, I believe the examination date are posted a year in advance.
Okay.
And we could either post the 10-day filing period at that time,
Yeah.
because we
okay.
haven't done it before, so we'd have to find out where it works best. So
Yeah,
we
I
could
see.
do it at that time,
Yeah.
or we could indicate that a 10-day
Because,
window.
yeah, because you can't give a notice from tomorrow, 10 days you can file.
No.
And so the 10-day window will be ahead of time advertised. Okay.
And the other change that we are making is in section G. And this was allowing the candidates to either bring a subject or serve as a subject for a subsequent examinee. We've changed that they are required to bring a subject for the ear impression and audiometric assessment portions of the practical examination period. And they can't turn around and be a subject for a subsequent examinee. And I believe if you're a subject now, you cannot be a subject for the following 12 months. The next change we made was 1399.121, inspection of examination papers. And I believe this is when we had the written exam, the written examination papers given to the Bureau back in the day. Now the only paper we get is from the testing agency on whether the person failed or passed the written exam. And that would be the only document that we would keep in their license files for the life of the file.
And my question to that, that's the life of the file, is that just a standard record retention schedule?
Correct.
Which is?
I believe it's active, obviously, for as long as it's active. And then after cancellation, it's 5 years, and expiration is 5 years. And then it goes to Secretary of State.
And just one thing on the heading, it should probably say records too instead of papers.
Yes.
Yeah, I don't know why it says inspection. That's a good point. So retention of examination records or just examination records?
And should we say, retention of written examination records? Because we don't get
Sure, I think that's
practical
fine.
exam. Okay.
Yeah.
And then the next change that we're looking to make is in 1399.122, the practical examination appeals. We previously allowed a candidate who has failed the practical to have a 60-day window to appeal their test. we've changed that to 30 days. And we've also included between section A and subsection 1 and 2, it used to say just and. So they would have to appeal up on the basis of both sections. So we've included or. And or examiner misconduct and or significant procedural error. We also request that the appeal shall be in writing signed and shall specify the basis of the appeal. And we're also giving the board right to notify the candidate the results of the appeal within 60 days of receipt of the appeal. Before, there was no time frame.
Just curious, who's responsible for the appeals?
The 2 senior examiners, and I believe the OPES, the
We have,
professional.
we have a committee, an exam committee that actually oversees that process.
Well, how organized of us. Of you.
Are there any other questions on the language?
While we're in here monkeying with language, can we go back to the first page, F2, discrete? It's the wrong spelling of the word discrete.
Okay.
Should be ETE.
Okay.
That's probably how it is spelled in there, because
Is it?
basis
It is
in one
how-
portion is spelled wrong.
Well, that is the plural of basis. We had that conversation.
Yeah, that was correct, but, okay, so we're going to correct the spelling of discrete. Pure tone discrete.
Along with doing it, the sweep frequency threshold type audiometer has been gone for close to 40, 50 years.
I used one in my CFY. I know I did.
I know.
That was only 40 years
I
ago.
I rest my case.
Well, and that's why we're here. What should we do with number 2?
Pure tone discrete threshold type audiometer.
So just take out
sweep frequency.
sweep frequency.
Or sweep.
How about just a pure tone audiometer?
Okay, so we think, what are we proposing? Pure tone audiometer?
Pure tone audiometer.
And in the number 3, it's called a speech recognition threshold, not reception. That changed about 20 years ago.
I'm sorry, which one was that?
Under 3, just the next sentence down, appropriate equipment for establishing its speech recognition threshold.
Okay.
And we call it word discrimination, or word recognition is also, they changed the names 20
So
years
it
ago.
should read, appropriate equipment for establishing speech recognition threshold.
And those should be
and
capitalized, those 3 words.
SRT.
Mm-hmm.
Speech recognition threshold and word,
And word recognition is what it's called.
is that capitalized too?
It isn't.
Okay. And word recognition. And word recognition scores?
Well, the threshold is a threshold, so it's not a score, but word discrimination is a score.
And we're really going to allow that through Soundfield? That's crazy. Better scratch out Soundfield, too.
Yeah, not likely, not,
Yeah, that would be bizarre.
yeah. Through headphones, take out the.
Period.
Mhm.
Okay. Wait, is there a period after headphones?
Word recognition, we abandoned that a long time ago, yeah.
Are we proposing a period after headphones? Or just eliminating sound field?
Do you allow them to use recorded material for this? They'd have to have a CD player and other equipment to do all that.
I've never seen that.
So it's all live voice, that's how it's done.
I guess I haven't been in
Yeah.
a exam.
I would take out the recorded part then.
Sure.
regarding the recorded or live voice, I bet that people are going to bring audiometers that are have an iPad app that does everything an audiometer would do, and that would have the capability for the recorded speech word recognition testing.
Is that happening?
That's a standard of care in the clinic, so you
Yeah,
would
but this is different thing.
But for the examination, that does not happen, right, Brianne?
No.
It's live.
Wouldn't you want someone to use the recorded word lists in the examination the same way you would want them to use it in the clinic?
In a sense, yes, I understand where you're going with that. On the other hand, we're trying to look at competency, and that takes another level, not another level, but another arena of judgment on the part of the examiners for someone to use that and make sure they've used it correctly. And if the person didn't repeat it right, did they pause it correctly? And did they let them repeat? Or, there's some other aspects to it that come up, and we may indeed deal with those.
So by leaving it there, that doesn't necessarily affect our exam. Maybe we could leave that there and just take out what we know is outdated. So we're saying that sound-filled media needs to go, right?
Mm-hmm.
Okay, so scores through headphone and or recorded or live voice. Is that what we're saying?
No, because the sounds are
Okay.
always going to come through the headphones, and they're going to be delivered by recorded or live voice.
Okay, and or live voice. Or
No.
no, I'm sorry.
Through headphones by recorded or live voice, and or live voice.
Got it.
But we should keep an eye on that. If people do bring those, and are they allowed to now?
Well,
Could they bring
no.
any?
Right now we have the requirements for the exam that are already set. But what I'm getting at is when we develop an examination, this could come up, and if that's something that we go to in the future,
Yeah, it's
we
so
don't want to
covered.
have to write another regulation to allow it.
Right.
If it's already in place, we wouldn't have to do that.
Mm-hmm.
I need clarification of item number 5, F5, equipment designed for the evaluation and testing of hearing aid performance. What do you mean by this?
That is existing text.
I know, but it's required for the applicant to bring it.
Well, they are given a list in the,
So take it out if it's not.
But it actually says including but not limited to. So-
Including, it's
Right.
been, this has to come, but not limited. We can ask other equipment, but this has to come. There's
That's a good point. It's a good point, Amnon.
You might want to point that out.
is this when
Now
they're
I see what
talking
you're saying
about
here.
So
listen
this
to
is
the-
not equipment designed for the evaluation and testing of hearing aid. It's quite complicated equipment with a sound like the real ear that you put with a microphone, and you see the performance of the hearing aid on the screen.
They're not.
It's not something.
Subsection
small.
F doesn't say you're bringing it with you.
It says here,
It says
an
it shall
applicant.
cover.
It says first in F, the practical examination shall cover all the procedure
Right.
and equipment commonly employed fitting in this and this and this, and it lists
Right.
5. And then it says an applicant shall furnish all equipment and material necessary for practical examination. So if it's covered this, he has to bring it.
Right, but that doesn't necessarily mean that they have to bring that. That means that it's going to be covered,
In the
and whatever
exam.
they have to bring, they're told what they have to bring.
The
So
exam's
we
gonna
don't have
cover.
the list here of what they have to bring. Do we-
There are no issues with the candidates bringing equipment or the issues that are covered. So I think
Yeah.
that as long as it's covered, they may be able to address it another way. That's not saying that they have to bring that equipment. They're told what they have to bring.
So I mean that the board has a waiver to tell the applicants what to bring, regardless of this statute.
This reg is saying, this is what's going to be, what topics will be covered in the exam. And G is saying that when we send you a list of what to bring, including your subject, you are responsible for that.
And it doesn't say we'll send you a list.
It says the applicant shall furnish all equipment and materials necessary for the practical exam.
Which the
Yeah.
board sends out.
That may not be necessary.
they're directed to a 10-page booklet that we provide called the Candidate Information Bulletin.
Yeah.
That lists everything that they are required to bring, and only that list.
Yeah, I know, but it's not clear by reading this. It doesn't clear that the board may say you should bring only stethoscope. If the board read this, that's okay.
Well, I don't think we have an issue with the candidates as far as what they need to bring. That's never been. That's pretty clear in the information that they're getting. The regulation is telling us what needs to be covered in the exam, and that the candidate needs to bring all that's necessary to take the exam.
That we request them to.
Yeah.
Right. So the exam developers determine what's necessary to bring.
I
based on all the
understand that
subject
that's
matter.
the practice that the board is doing for years, but what I'm saying, it's not exactly what the statute. So there's no argument. Nobody complain when they tell him don't bring it.
Right.
Yeah, I know. Okay.
Can I just ask that everybody brings a portable, or in one form or another, a portable audiometer?
Yes. They bring their audiometer, yeah.
Okay, and they're doing the testing, pure tone testing in the same room with the subject?
Yes. Yeah.
So the SRT part of this couldn't be done in the same room with the subject, so they'd have to be in separate rooms. So is that just covered under, because it falls under the practical exam portion of this rather than the written, which may be kind of what he's talking about also, that maybe these should be split a little bit, because you can't do that in the same room with someone.
Why?
Because they can hear you. That negates the test.
But the way that the exam is actually run, like that isn't what this reg is designed to cover, because that's how, an exam is administered. That's operating a little outside of this. Is
Okay.
We just tell them what's covered, what's expected of them, why you'll be removed if you're cheating or whatever. The actual logistics of running the exam, or whoever, if the third-party vendor is running it, the logistics of what room you'll be in or anything like that is not covered in this
But
reg.
this is under the practical exam, under F. It starts the 1, 2 through 6. Does that suggest it's related to the practical exam? Is that not, am I reading it
Says
wrong?
So she's talking
F.
about the fact that the exam will cover the appropriate equipment for establishing SRT and word recognition.
You really can't do it with portable audiometer. There are some that come with microphones, but not many.
Yeah, I think that what they're looking at the exam, if I'm not mistaken, is how you do it. Supposedly the subject will be in an isolated room. It's just the technique that you do. They don't ask for accurate results, but just the technique.
Oh. We don't have to have accurate results. What was I thinking?
No, you don't have to have accurate result in the test. No, not at all. By the way, you can still pass the license without doing the whole audiometric, as I understand. It's not enough point to fail you. If you do everything fine and you don't know how to operate an audiometer, am I right that it's not enough point to fail you?
I think,
don't
can I just
know.
say something? I think we're all talking about something that may be beyond the scope of what we do.
Okay.
The staff don't administer the exam. That's something that's done by the Office of Professional Exam Services and the experts that are involved in that. So I think the purpose of this regulation was to just go over, clarify language, and if there's something here that doesn't make sense or we need to revisit, then we can revisit that. If we need to look into the SRT part of it, but I don't think that the language is necessarily saying that how that's being done. It's saying that the practical exam is going to cover that topic. So I'm not part of that process as executive officer. You wouldn't want me to be, but I'm certain that they're covering that in the exam, and I can look into that further if that's what the board would like me to do.
Well, if we're removing some of the language in here because of its antiquated nature, then there's others in here too. Can we look at those?
Sure.
Okay.
If something makes absolutely no sense being in here, that's actually why we're here, because these regulations, we know they're old, and we want to make sure that it works for today, that it makes sense.
So I'm looking at 4. I'm not quite sure what a calibrated sound
Yeah,
pressure
neither am I.
instrument is.
Yeah. What is that?
Is that an audiometer? It sounds like you're talking about hearing aids, because master hearing aids haven't been around for about 60 years.
I've never actually even used one. Yeah.
I've seen a picture of one.
I've read about them in some antique textbooks. Yeah.
Types of hearing aid simulators.
Yep, not sure what that is. But
Okay, so what I would suggest then is that we go back and that we do a little bit of research on some of these items. We may need the expertise of board members to help kind of guide that conversation.
Okay.
May I ask a clarifying question about one of the changes that was proposed? The 6G, the part about how the exam applicant has to bring a subject and they can't use someone who's already like coming with them. Why was that changed?
I can address that. We work through the Office of Professional Examination Services. They're actually tasked with making sure that we abide by best practices. There are some recommendations that they made for the purpose of exam security, and I believe that was one of those recommendations.
Okay, did they look at kind of the burden that might place on the applicants?
I'm certain that what their task was to ensure exam security, and I think that while some things may place a burden in an application, exam security and consumer protection are always going to take priority.
And their concern for the kind of security during the exam,
Yes.
was it something that could be mediated in another way?
You know,
This is also
yeah,
the
this
forum
is
for
off
that.
topic, but I can
okay.
tell you that.
I think I'm concerned about this change because it's like very difficult. as a
Well, I will
student.
tell you though, if you are concerned and interested in the exam, we're always looking for subject matter experts to help us. We'd be more than happy to have you be a part of that process.
Got yourself a job.
All right then.
What you asked for.
But then,
And I'm not-
this is
and-
going to be changed no matter what.
And I'm saying this sincerely. I'm not saying this
Yeah.
because I'm trying to. We really do need
I had to
subject matter experts.
beg, borrow, and bribe an extended family member to come, and he didn't want to, and he would never do it again. So it's just really difficult.
Yeah, and it's difficult for me to address all of these issues because these are issues that were discussed over a lot of research, over a lot of discussions with the OPS. That's how we as a board maintain our accountability with this exam. We actually look at best practices and look at psychometric experts.
Okay.
So it sounds like what we need to do here is go back to the drawing board with some expert advice and come back to the board with this. It's not ready for prime time. Can we go to 14E? And 14E is actually part of a discussion that the board had for some time. One of our strategic goals is making sure that consumers, stakeholders are educated and informed about the board, basically. And one of our objectives was to require practitioners or licensees to display a consumer notice at the practitioner's point of service regarding the roles and responsibilities of the board. We have some proposed language here. I want to make sure that I clarify. Amnon made a suggestion in a board meeting that when a licensee is disciplined and becomes a probationer, they have to notify their clients of the board, how to file a complaint. And there was some information that was included in that, very simple information. This is different than that. This is actually all licensees notifying the board, notifying clients of the board's existence. So this is something that has already been done with other boards, notice to consumers.
Yeah, I looked at what the medical board required and took their language and tweaked it for our purposes.
But yeah.
And
Yeah, but I see there is also a requirement in B2, including the notice in a written statement signed and dated by the client or the client's representative and retain the client's record. So each customer that has to get, besides the one on the wall, has to get a written receipt about this?
No, one of the following. B is one of the following. So either They have to have a notice on the wall where their
Oh, I see.
clients and
Okay.
customers can see it, or they need to sign something to have in their file.
I see, okay.
The language is pretty straightforward. Do we have any comments, or is there any discussion?
Can I, I think it's great when I go even to a spa or, to get my nails done. They
Right.
have a little sign or automobile. So how much more important your health is.
Yeah.
That's all. So I think it's great.
And this addresses a comment too from I think it was Marcia, who talked about how many complaints we're actually getting from consumers. And my response to that was I was surprised at the number of consumer complaints that we get, because I talk to people all the time that don't necessarily know the existence of the board. So this is part of that outreach to make sure that consumers know who we are, what we do, and the very fact that we exist.
Include the schools?
Yeah, I was going to actually mention.
Because we have SLPs who are only licensed.
Well, I was going to mention that in addition, I think we're thinking in terms of healthcare providers primarily. All of us have seen these notices in healthcare providers, but this would also, I think this is great, but this would also require, I believe, schools to have some kind of notice, because if the SLP that they have employed or SLPA that they have employed provide services at the school.
And SLPAs are in the schools by virtue of our license, not anything from CTC. They're there because of our license.
Yes, and so this will be interesting
why I put
because
down
you don't expect to see that in
a
school. But that would be up to the school district to figure out how to comply.
Yeah.
But I think that that's great because it provides more of a knowledge base to those who work in schools that the SLP might be licensed and the SLPA will be licensed and has laws and regulations to follow.
Despite the fact that it's not really in my jurisdiction under HHP, what you might consider in those situations would be either some sort of form that a parent might sign that they're aware of the fact that a speech-language pathologist is licensed and regulated by this board so that they would know what the oversight ability is, or some sort of separate educational designation within these guidelines, because I think that the main point here is on the consumer notification. The other thing that I would recommend that you look at is maybe on the Prop 65 warnings that are up in pretty much every place in California. So there is some level of signage either in schools or apartment buildings or laundromats or whatever have you.
Is that the birth
That's
defects
right, yeah.
one?
Yeah.
I have seen them posted in private schools.
Good afternoon, members. Again, Kurt Hepler, Supervising Staff Counsel. Just conferring the RPE required professional experience. Is that actually a licensed category?
Yeah.
Yes, it
So
is.
it says SLPs, SLPAs, required professional experience. I was just curious if there's another way that could be termed, licensees seeking or persons acquiring the necessary, because it's sort of a
I had
nonsense.
the same thought. It's like, that doesn't sound like a person. It sounds like an
Exactly.
experience.
Exactly.
Yeah, so
So-
somehow to designate that that's an actual licensee.
So that was my only comment. So thanks, members.
Term that you could use, you could say speech language pathologist completing their required professional experience.
But they're not a speech-language pathologist yet.
They have a master's degree, so they are a speech language pathologist, but
An audiologist isn't.
as far as I know, they are. They're completing, they have a temporary license called a required professional experience.
No, they're not. You're right, Allison, and in that sense, because we have the 4-year, the third year is still, they're still enrolled.
Yeah.
Required
Still
professional
paying
experience
tuition.
licensee?
Right, but they're not enrolled anymore. It's a different profession.
Yes. Do it. It's
They've completed their entry-level requirements and are speech language
We'll
pathologists.
just say required professional experience licensee.
Licensee, because they're not a registrant, they're licensee.
Right, and I think what's important is that the consumer reading this knows that the person providing them services, the licensee providing them services, is regulated by the board. Most people probably will not know what a required professional experience person is, but they will think, oh, that person's an audiologist or a speech language pathologist. Maybe they're not completely clear on the type of license they have, but that will trigger, they're regulated by this board.
I seen RPE, they use their name SLP CFY. So clinical, they typically refer to themselves as clinical fellowship year.
That's because of the national certification, though. They're just indicating their national certification rather than their state license.
Yes.
We can call them almost SLP.
So it stays, do we want to add that word there or not?
So we're adding licensee after RPE?
Licensees?
Licensees, thank you.
I'll have to get out that special motion
Can entertain a motion
to accept this with changes.
to
The special paragraph motion?
Yeah.
Okay, so the if somebody's going to entertain a motion, I'll go ahead and state it, and then somebody can tell me if they like it. I move that we approve the proposed text with the edits, adding the word licensees after required professional experience under Article 8 miscellaneous on the second page of your materials. So we approve the proposed text with those edits for a 45-day comment period and to delegate to the executive officer the authority to adopt the proposed regulatory changes and to follow established procedures and processes, and to also delegate to the executive officer the authority to make any technical and non-substantive changes that may be required in completing the rulemaking file.
So moved.
Second.
Any discussion from members of the board? Okay. Any discussion from members of the public? Then we'll call for the vote.
Yes.
Yes.
Aye.
Yes.
Aye.
Yes.
Yes. Motion carries. Okay. Next on our agenda, number 15, is the executive officer's report.
So behind tab 15, you have my report and then a series of reports from staff regarding we talked about our budget yesterday, an administrative update, licensing, the practical exam, and enforcement. I don't have a whole lot to report. As you all know, we are losing, or we have lost, Anita Joseph. After when I started, she started shortly after me and helped us a great deal in enforcement with formal discipline as our coordinator. And she has moved on to another job, which offers her a career opportunity, and we're going to miss her. That leaves a vacancy in enforcement, and as you can see, Marty and Karen, juggle several different things. That's part of being part of a small board. But Brianne and I are recruiting for a new special investigator to help us in that area. We've also had two vacancies, one in licensing and the other one in admin. One of our challenges is that we have one support person for the entire board. So we have to, we're constantly hiring temporary staff, looking for ways, workarounds to get human beings to come and help us filing and opening of mail and sorting of mail and whatever we can do to make the work happen. And that kind of lends itself to efficiencies, because what happens is, you know, we have managers, we have associate journey level analysts sometimes that have to get in and open the mail and do things that we should have clerical staff to do. But that's kind of the world that we live in right now. We are in the process of pursuing additional positions to grow and to have adequate staff for the various tasks that exist in the office. We've had that receptionist vacant, and that contributed to a little bit of a bump in our licensing. Not necessarily a backlog, but there were delays that we had not anticipated. So the good news is Monday we have 2 people starting. One is an analyst who's coming to us. I don't remember where they were employed, but I did meet both of these people. I interviewed them. Brianne's done a great job of recruiting staff, and the other one is a young man who's going to be our receptionist. Right, Brianne? They're starting Monday. We have to make room for the people that we have in our office, so we're scrambling. We're turning storage rooms into office space, and there's a lot going on behind the scenes. We're meeting with DCA facilities, are really working hard to help us exist in this building. So that's where we are right now. And hopefully the next time we see you, we will be fully staffed and people will stay put. That's not realistic. So, any questions on our personnel? I just want to make clear too, as part of our budgets discussion, I kind of mentioned it briefly. We are looking to increase our staff. It's a constant process. It's a 2-year process. So I'm trying to propose additional staff today that would start in 2019. Is that right, Brianne? Yeah. So it's a process we have to go through. Just to kind of give you a picture, it's kind of like legislation, but you go through DCA, then you go through agency, then it goes to the Department of Finance, legislative analyst. These are all the people that we field questions from. If we get through all those hurdles, then we actually go before the legislature and present our proposal. And sometimes it's to just get limited term positions or a half position, but that's kind of what we do. So that's what we're going through right now. The rest of your report, there's some information on licensing. On the second page of my report, page 2, you can see the licensing cycle times. I've just kind of kept this to kind of give you a picture of where we are today, where we were last year. This peak season hit us pretty hard. We were about 4 weeks out in licensing SOP and audiology applications. It was a big push by staff. They worked overtime. They really worked hard to keep those numbers down. They know how important that is. We held 2 practical exams on March 18th and June 3rd. If you read the DCA annual report, you will read that we have made some changes to actually streamline the practical exam. So that's going to allow us to increase our capacity and examine more candidates, which is why we want to have the regulations in place to be able to do that and not have to limit ourselves to 50. In enforcement, there are currently about 16 disciplinary cases with the AG's office. That is actually less than what we've had before. And the life cycle of a formal discipline enforcement case, I know we talked about this quite a bit yesterday, is typically anywhere from 18 months to 3 years. That's just how long these cases take. And when Anita was here working with us, we were working on workload that existed from before. So now we're somewhat current. I think the last few times I reported to you, we probably had anywhere from 20 to 30 cases that were pending. Now that number is at 16. The number that has gone up is we have 32 probationers. 8 of these probationers require drug and alcohol testing, and 8 of them are in told status. We also have a table that follows that shows all the discipline from this fiscal year. This is a complete picture of all the licensees that have been disciplined for the year. Are there any questions so far on my report? We have charts to follow that kind of detail what we were talking about. If you have any questions, you're more than welcome to ask them now or to ask me at any time.
Sure, it'd be nice to split the speech pathologist from the audiologist.
That's a question I was waiting for.
Oh, yeah, I was right behind you, Marcia.
Yeah, to split the complaints here.
Well,
SLPs from audiologists.
so the question Marcia had, and I'm going to hand something out. I'm sorry I didn't do this earlier. So I was so engrossed in our conversation.
Aha.
I will say that it is difficult to kind of parse this because of the way our system works. We are still on the legacy CAS system, and it has its limitations. But what we're going to try to do is at least do a year-end report where we bring this information to you at the end of the year and summarize what we have. What you have before you is a chart that breaks down speech-language pathology, complaints, speech-language pathology, audiologist, SLPAs, and RPEs. We tried to categorize the types of complaints that you're receiving, and I think that's the information that you were asking for, just to kind of give you a picture.
Yeah, and so.
Uh-oh.
Now I'm gonna say, are the RPEs speech or audiology?
Because there are codes, we didn't delve into that, but the majority of them are going to be speech.
Speech, I would
Yes.
assume, yeah.
And just to kind of, starting from the bottom up, the complaints that come in for RPEs, because they're applicants, are usually previous convictions. So when they're in the application process, we find out that, you know, I hate to stereotype it, but typically what you find out is that there was a DUI in the past, or, you know, wet reckless, or somebody had too much to drink on a campus somewhere.
Like prior to the time that they were RPEs?
Yes.
Yeah,
Yeah.
well, that's interesting.
And the board receives that information, or they disclose it. Either way, we get the information, whether they disclose it or not, and that opens a complaint. As you can see, I'll start from the top now. SLPs are about 45. 45 of our complaints were from SLPs. The majority of them are convictions. And the next category is unprofessional conduct. Unlicensed activity, there were 3. Disciplined by another agency, 1. Audiologists, there were a total of 16 complaints. 1 is regarding a conviction, 9 unprofessional conduct. That's somewhat of a broad category, but there are a lot of categories that can fall into that. I think I lost Marty. She had some real first-hand information, but I know she had to go. Fraud, incompetence, negligence, unlicensed or unregistered activity. And if you look down at SLPAs, you'll see that we got quite a few complaints there. And the majority of them are convictions, but there's also a large chunk that have to do with unlicensed activity.
Question here. We have, let's say, for SLP, 45 complaints filed. This is throughout the whole year for SLP, 45 complaints were filed?
Yes.
Throughout, filed. Now, out of the 45, is there none of them found like non-substantiated or complete, or you know, find the not guilt, find that the complaint was not based on anything?
You know, that is a whole other category when we actually talk about what happens with the complaints. What I was trying to do, this has to do with our enforcement report. We've always broken it down from the hearing aid side on one side and speech-language pathology and audiology on the other side. So the licensees of the board have wanted to break down. This doesn't talk about the outcomes. This just talks about the type of complaints that we've received.
So you probably received more than 45 complaints?
No, this is what we received for the whole year.
So there was no complaint out of the 45 that found not
Well,
basis for the complaint. and-
18 were not convicted. So only, of the 45, only 27 convictions.
No. Let me clarify what we're talking about here. Okay. So, of the complaints that we received 45 total complaints for speech language pathologist. Those complaints, of those 45, 27 of them were for convictions that were reported to the board, whether they self-reported them or whether we got them on a subsequent arrest report. This is not the board convicting.
Oh.
These are convictions that they have with law enforcement. So we received 45 total complaints. This does not talk about the outcome of the investigation of the complaint. I want to be really clear about
So
that.
the breakdown, though, doesn't add up to 27, so is there other things?
Well, it's not going to add up. It's not going to add up to 27. If anything, it would add up to 45. But sometimes there can be duplicate categories. I would not try to make the math work here because
Okay.
sometimes there are overlapping things.
Okay.
But if you look at this and you look at our enforcement report, sometimes the math is not going to totally work.
Which one of the 55 complaint was found unsubstantiated?
That's not what we're reporting here. We're not reporting the outcomes. We're only reporting the categories of the complaints.
Okay,
That's a whole other report.
yes.
I can tell you, from my experience working with boards, and this has been pretty consistent across all boards. I shouldn't speak for all boards, but at least the boards that I've been familiar with, healing arts boards. If you get 100 complaints a year, probably around 10% of those result in some type of enforcement action. Maybe another 5 to 10% result in citations, but it's a very small percentage.
The majority of the complaints are found not substantiated.
Yes, for some reason or another. They can be out of jurisdiction, they can be insufficient evidence, there can be other categories that are involved.
So the way the math works here, that because the numbers do add up, there's no way to understand what percentage of these convictions are related to a given type of negligence. It's just convictions. The breakdown for the other rows is more specific to what the complaint is about, but the convictions themselves don't say anything about what the nature of the conviction is.
No, and I think what's confusing us is the word convictions. So
Probably DUI or something.
right, if you look at our enforcement report, the way the database categorizes it is complaints and convictions. So a complaint can be for negligence, right? A consumer complains, and that's grounds of action are based on negligence. We also get subsequent arrest reports for every licensee. They're fingerprinted. You're fingerprinted with the DOJ, the FBI. If you are pulled over and you are considered intoxicated, driving while intoxicated, that report is going to come to the board. When it becomes a conviction, that becomes an issue with the board. So we categorize it as conviction, an arrest or a conviction. That's when we're going to open a complaint. So that is a separate category in itself. As you can see, we get most of our complaints are from convictions in those categories. So this has nothing to do with the board convicting anyone. This has to do with law enforcement agencies.
And I was just going to point out that if you add up the total number of complaints and convictions for SLPs and SLPAs, that's a total of 83. And if you look at the total number of licensees who are SLPs and SLPAs, it's approximately 21,800. So it's an extremely, extremely small percentage of complaints and convictions for our licensees.
It is actually, and I think last year I reported to one of the associations. I pointed that out, that for the size of our licensing population, we have a relatively small small number of complaints or convictions. Now that could be good, but it could also be bad.
We don't want to tell the
It
sunset
could
people
be that people don't know, but that's why we're doing the good work of making sure that consumers know that we exist.
Yeah, and that's another really good point. When we see that the vast majority are convictions, which are typically DUIs more than anything else, I know just anecdotally that a lot of people complain about their fellow SLPs or SLPAs, and there's surely more out there than are being
Right.
than are submitting complaints.
Right. That's all I have for my board report. Are there any other questions?
Thank you very much for breaking down audiology and speech
Yes, so you try to
pathology.
do something nice and people jump all over you.
I think, honestly, if Marcia would not have reminded me, I don't think I would have taken that out, and all the work that.
So am I,
Marty
it
put into
looks
that.
like there's this huge jump in audiologists licensees from last year. Remember, we only had one, and we made that helped us get that bill through. Now it's 19 something.
Yes, we have seen an increase.
That's a big increase.
Oh, that's right. Thank you, Brianne.
And it's listed there.
The way we're calculating the total number of licensees, we include those that are delinquent, those that are inactive, people that might have holds on their license because of they didn't check a box, continued education, or so we want to give a more accurate picture of the number of licensees that we have.
Oh, okay.
Can I ask a question about that?
So it's not apple. It's apples and oranges here.
So how are you defining, when do you finally take someone off after they're delinquent? I mean, do you just switch delinquent to inactive?
There's
or-
a statute on that. After so many years, right?
One of them's 3 years and the other's 5, and it's
Okay,
hearing aids and speech and audiology.
So there's a statute that tells us when.
okay, so it seems like after 5 years, if you haven't paid, you're no longer,
Right.
you're listed. Got it, thank you.
But the delinquent category also is just folks that just missed their
Yes.
expiration date.
Yes.
And they correct it within the next 2 months, say.
Yeah,
And then they're removed immediately, once they send in the delinquent fee.
great, thanks.
And I don't mean to sound like a broken record, but in the category of RPE, is that SLP or audiology or both?
That's both.
Okay.
Are you ready to go to the next topic? Okay, well, I'll go ahead and take us over to tab number 16, and it's a legislative update. I don't have really much to report. I did include, I tried to include the bills that affect the board or that I thought the board would be interested in. Some of these legislative bills were given to me by certain board members. So if you want to talk about any particular bill, now would be the time to do that. We know that AB 387, we know that bill died, and that had to do with the minimum, that was the minimum wage bill for interns, right? We talked about AB 612 yesterday, that hearing was canceled. We don't really know the status of that bill, but at this point, it's not moving. AB 827, I thought, was an interesting bill because we're talking a lot about applicants from other countries. And this kind of gives you an idea of how the legislature sees it. They're actually looking for ways to put immigrants to work and to make it easier for them to get licenses. So that's something that, we're going to definitely have to consider in any changes that we make. Allison, did you want to talk about AB 1601? That's the hearing aids minors.
We don't know anything new on that, right?
I know it's still in committee.
Okay, yeah. It's, what is this now, the fourth time similar legislation in my memory has been introduced, and I had the impression, I think from our last board meeting, that the likelihood of passage was kind of slim. But it sure is a good idea. I think when this bill came up the last time, as I recall, the estimate was that it would add about 5 cents per health plan to provide coverage for kids' hearing aids. So we're not talking about dollars and dollars and dollars.
Really?
Yeah, it was a minimal amount, just because, even though in our world there's a lot of hearing loss compared with other birth conditions, in the bigger world it's still considered a low incidence disability. So it's a pretty minimal amount of money. Just the fact that it's been tried 3 times before and failed, I'm the anti-Pollyanna on this, but we'll see what happens.
Yes, please do.
I just asked Paul for permission to go back to AB 827. It's not just at the legislature level statewide, but there are counties and there are cities down south, at least, where we live, that we're hearing you must provide pathways for immigrants and make it work. So it's filtered down.
And I know we all talked about, I shared with you the Little Hoover Commission report on barriers to occupational licensing.
Yeah, that was fascinating reading. Yeah, that really was fascinating reading.
I'll go back to AB 1706, but let me just go down the list here. SB 715, this is another interesting bill. I think this one was actually postponed by committee, but this bill would specify that the governor may remove from office any member, a member of any board appointed by him or her for failure to attend board meetings. I think that's just kind of adding or clarifying that language. And it does say appointed by him or her, so that doesn't affect those members that are appointed by the Senate or the Assembly. And then there's SB 762, which is a bill that would require hearing arts boards to waive renewal fees for inactive licensees who become active to serve in medically underserved areas. I've included the language of the bills as of when we printed this. I don't think anything's gone on to change that. And I wanted to also talk about AB 1706. Our bill was merged with the Physical Therapy and Occupational Therapy Board, and that is our bill. That is a bill to extend this board to January of 2022. Is that right? It is. Yes, it is. Which means we won't have to do another census report until 2021. And for this bill, since it's a new bill, we may want to write a letter of support for ourselves.
Will do.
So,
Since we have cash representation in the audience, it would probably be very nice to have CASHA write a letter of support for AB 1706, supporting the continuation of the board.
We're on it.
Thank you.
You listed SB 198 in the agenda, but there's nothing here about it. And the only reason I want to talk about it is I got an email from an audiologist last week saying, actually was forwarding an advertisement for a training course, and in it was offering to train a number of things, but included in that was cerumen management and tympanometry for hearing aid dispensers. And now this is a national agency; it sends it out to every state and probably doesn't know the regulations. Do we need to care about that, or talk to them, or advise this organization about California, or is it just we expect our California licensees to know the rules?
I would imagine that it's their responsibility to notify the attendees of the class that that they need to abide by the laws of the state that they're a part of.
Yeah, I'm not sure it doesn't say that. I'll have to look at the ad again. But if it doesn't, that is in our purview to contact this agency and
Well,
ask them
I
to
think
do
we
so?
could, but I mean, I would probably be careful not to try to police all the national organizations out there. I know, for instance, ASHA, when they talk about applications for, foreign trained applicants, they tell them, and, despite the fact that we certify you, you need to check with the state licensing board for which you're applying. I know that those training courses have existed. If the board so chooses to do that, it's up to you.
I think that since there hasn't been a change or an addition to the privileges, that I don't know that there needs to be anything like we need to pursue any active. I mean, if there was a change from then till now, then it probably would be worth either notifying them or our licensees, but since nothing's changed.
Okay. And I did notice that it was on the agenda, but I know we reported about it last time, so I noticed that after we went to print. Sorry about that. That's all I have for legislation, Madam Chair.
So regarding AB 1706, our sunset.
That's right.
You included the legislation that's currently moving forward. Is that what we're going to talk about right now, or are we done talking?
No, actually,
It's under 16E.
Right.
Are we going to talk specifically about 16?
If you have questions, I can certainly
Okay.
answer them.
Yes, actually, I have comments. So this is the first time that we've been privy to the actual statutes that are being proposed by the legislature. And so I noticed a couple of things.
I think it was in our last binder, but it was,
Was it?
under a different bill number. They just merged it with some other boards.
All right, then,
But
at any
please,
rate.
go ahead.
Yes. So, so I was particularly concerned that the statutes that have been included in our bill really pertain pretty much exclusively to hearing aid dispensing. And there were other statutes that we requested, one of them being the elimination of the speech pathology aid designation, and the other one in the area of English proficiency.
Let me explain that. I can answer that question.
Okay.
That's a good question. I asked the same question several years back when I was working on a different sunset report. Basically, this is a sunset bill that you don't want to be controversial, and by controversial they mean anything that anyone would oppose. I'll give you for instance, I think a few years back there was something in one of our very large healing arts boards that was controversial. They were asked not to include it in the bill, and it resulted in that board being sunset. That board found out we're no longer a board, I think a couple of days before they were sunset. So what the staff will do is we talk about what of all these proposals is non-controversial, can we put in, get it passed as low-hanging fruit, and then some of those other categories we can talk about later. One thing that Dee and I discussed earlier was we're going to table item number 12, which talks about locked hearing aids, and have a little more discussion offline before we bring it to the board. That's another one of those proposals that we know that if we stick it in our bill could get opposition. We don't want our board to be sunset. So that's why this is just taking care of some of the the non-controversial things that would allow our bill to be sunset.
And I completely understand that. But the language that has to do with English proficiency is in the physical therapy board statutes. Exactly what we want to say.
But that's already
is-
part of their law. That's what's different. They've already actually talked about it. They've been through this a few times, and this is the first time for us. So that's the only explanation I have for that, because I know that it already exists in their law. But I tried to get everything that we proposed included, and when I'm presented with that, option, I think that we can try to continue to pursue that, and I think we are. I don't think it's over yet. As far as those proposals we made some very good ones that we need to, continue to pursue.
Okay, it's disappointing. I understand that we're trying not to be controversial, and we certainly want to continue as a board. I do understand that, but I do hope that we, hopefully when AB 1706 is passed and we continue to be a board, that we can bring this up again. These are still areas that need to be addressed.
Sure, absolutely.
Yeah. Okay, thank you.
I think we need to entertain a motion to write a letter of support for AB 1706. If the board so chooses. If the board so chooses.
If the board so chooses, would you entertain a motion that we write a letter of support for 1706?
I move.
Second.
It's been moved and seconded. Is there any discussion from the board? Okay. Any discussion from the members of the public? If not, we'll call the roll.
Yes.
Yes.
Aye.
Yes.
Aye.
Yes.
Yes. So moved. Thank you.
Now, the last item on the agenda is future agenda items and future board meeting dates. Maybe first we can tackle are there any agenda items that we're proposing for committee or for board meetings? And you can always send them to me. Yes.
So we have that speech language pathology practice committee meeting on August 28th, I think it is. Do we also want to include that on have a practice committee meeting also for our October meeting? Or I'm not exactly sure how that's all going to work at this point.
That's up to the board and the committee, based on whatever issues you may have to discuss.
So, so I don't think we don't know until we have our
We
August
can decide
28th
that
meeting.
at that meeting, at the
Yeah.
next meeting.
Okay, that sounds good.
Just I want to just talk about the agendas, because I have Sabina here, and I know she could probably chime in on this too. When we come up with items for our board meeting, it's really important that we have that we be as specific as we can be, that we have some direction in what it is we're trying to accomplish. I have because we have with us also, we have staff from DCA that actually talks with, they work with me on these agenda items. And a lot of times it's really difficult to give those updates and know. And there are probably a lot of reasons why it's important to do that. Maybe, Sabina, you could just chime in on, as far as agenda items, since this is an issue that your office brings up with me, you could talk about why it's important that these agenda items be specific.
So basically, what I can tell you what I do when I get an agenda and review it prior to having it approved for posting. I try to also, one of the things I try to always do is look at it from an outsider's standpoint. So if I were wanting to attend this meeting, would I really know what would be discussed? Is there even a remote chance that the board is going to be able to take, or is going to take some action on an item? So I know one of the sticking points we had this last time was the telehealth item, for example. And I know we went back and forth a lot, and even with staff, trying to figure out what the board was really looking to get at in their discussion. It's not enough to say telehealth discussion, right? So we need, when we talk about a future agenda items, here, it's okay to give us a general subject or something like that, but you can then follow up perhaps, or let us know you're available for staff to vet out that agenda item a little further and a little bit more detailed, closer to the meeting. And that would be very helpful, so that we know how to frame the agenda item. So you can also, so the board can do what they want to do, instead of staff and me and Paul guessing maybe what your intentions are and what you truly want to be able to address. And instead of us trying to craft an item thinking we have your ideas in our heads, which we don't often.
Right, and I think it's really important that the board talk about those issues that the board deems important. This is your meeting. We don't in any way want to quench that discussion of the important issues that you have. What is helpful to us is that when you present an issue, that you give us some type of background and, some type of plan as far as what we're trying to accomplish. The reason for that is that we, unlike other boards, we don't have a specific person designated to handle legislation and regulations. So we all kind of try to share that. We kind of try to handle that in-house. We're working towards that. We're not there yet. So as much as you can, please help us out there.
I appreciate your comments, and I can understand your point of view. And I guess as a board member, I think all of us board members would agree that when we encounter something in our practice, there is some level at which we know, hey, this is a problem. This is not working the way it's supposed to work. This is not protecting consumers. We're heading down a path that maybe we shouldn't be heading down. We may not be able to articulate what we think we want the end game to look like, or even how to get there. But I do think it's very important that we all feel, even when we don't have the answers, when we don't, that we all feel confident in approaching the board staff to say, look, I don't know the answer, but I feel in my gut that this is a problem. And then help us to articulate it. But I think what we want to do is really invite and encourage the board to bring those issues up, because that's why we're here.
Right.
And I agree. Can I just say something? Because I agree with that, and I totally advocate for that. I know I've had experience working with several legal counsels. Sabrina could probably attest to this. Sometimes we keep things on the agenda that maybe DCA doesn't want us to keep on the agenda, because I really think it's important that we work through some of these issues and talk to them. So please don't take this as a don't come to us unless you have a whole, bound report of 500 pages. Nothing like that at all. We want to have that discussion, but it would be helpful if, as much as possible, you can give us those background.
Right, and like I said, I corresponded with staff too, but, I know you guys at least well enough, if I continue to be counsel, that I can at least reach out to you guys and have that conversation, because you guys are the experts. I'm not. And you can, and maybe throughout a conversation, we can figure out how to exactly make that happen.
Mm-hmm. Good, and I think by the same token, we want to encourage our patients and our professional organizations, and perhaps even our colleagues in other fields. I mean, I think that we want to be open to a number of aspects of our practice that there may be things coming down the road that maybe we can't really articulate exactly what it is, but we know it's a problem or a potential problem. And we want to, be open to that.
If you have any future agenda items, just please send them to us. I'm sorry, go ahead.
I was going to tag on to that, Allison, in that now we are working together with other professions. And I know that Kasia has been working on that. Burl's going to other meetings, and the OTs, the PTs on our campus are now working together. And that may lead to some new things in the future, but we're no longer in silos.
Yeah.
Did we want to go over the calendar? We've included on the very last page the calendar of dates. Brianne or Karen, are there any dates that we need to clarify, or are there any changes that we need to look at?
November 2018, we have a tentative board meeting on November 8th and 9th.
Okay.
And the ASHA convention in Boston is the 9th through the 11th.
So we may run into the same issue that we ran into in 2017. Mm-hmm. So we probably need to look at the end of October again. So if you could all maybe just make a note to yourselves to look at the dates surrounding November 8th and 9th. I think it gets harder as we go down into November, so we may need to go into late October again. Any other questions or comments on the calendar?
September 2018 CA convention is in Anaheim,
Okay.
and I thought I just saw the American Academy of Audiology in, oh, that's 19.
And if you have other events that you think need to be on our calendar, please feel free to send them to Karen.
And our next board meeting, why am I not seeing it here? Oh, board and committee meeting, Southern California, October. Okay, so we don't have a venue yet for October of 17? Okay.
There's LA? Or
I
just,
think we're
we don't
broadening
even
it to
know.
Southern California.
All of Southern California.
That's a big spot. Okay.
Where are you drawing the line, Paul? What point are we in the south?
South of Bakersfield.
Oh, okay.
You can't be serious.
That's all we
We're
have.
done.
Yes, I think we're ready.
Let's adjourn. Huh? Let's adjourn. Okay. Thank you for everyone who joined us from the public, and would you like to say something?
We talked about that. We're going to table that for the next
Oh,
meeting.
yeah.
Thank you.
Then we're adjourned.
Wrap.